Welcome to Claim Amendments in IPRs after Aqua Products. My name is Tim Bianchi and I'm a principal patent attorney at the firm of Schwegman, Lundberg, and Woessner. And in the next 10 minutes, we'll discuss some of the practical impact of the Aqua Products en banc Federal Circuit decision. First, we'll be talking about IPR amendments before Aqua Products just to lay the groundwork of what past board practice was. Then we'll talk about IPR amendments after Aqua Products. And in specific, we'll talk about the practical impact of Aqua Products on IPR amendment practice and some questions that are raised by the Aqua Products decision. Let's talk about IPR amendments before Aqua Products. Before Aqua Products, patent owners could file a motion to amend to substitute claims, amended claims, for existing original claims, provided those amended claims do not impermissibly enlarge the scope of the original claim, do not introduce new subject matter, provide a single substitute claim for each claim being amended, unless a showing of more claims being necessary could be provided to the board. And also those claim amendments had to respond to an instituted ground of unpatentability. A motion to amend had to include a claim listing showing the changes clearly and setting forth the support in the original disclosure of the patent, or support in an earlier filed disclosure if a benefit of earlier priority is sought. The motion to amend could be contingent. In other words, a patent owner could file a motion to amend stating that if the original claim is not deemed patentable by the board, then to consider a set of amendments in order for the claim to become patentable via the amendment. In any case, the patent owner was responsible for demonstrating that the amended claim was patentable over the grounds of rejection and of the known prior art. The patent owner had to explain why the amended claim language was patentable over all art of record and all art known to the expert. This frequently included testimonial evidence from an expert to support the motion to amend the claims. And patent owners followed the guidance set forth in Idle-Free Systems and Master Image 3D. All this changed after Aqua Products, because according to Aqua Products, now the petitioner and not the patent owner has the burden of proof. So in this case, the petitioner has the burden of proof to show that the claims and the substitute claims are unpatentable. The majority opinion distinguished the entry of a motion to amend in the IPR from the substantive burden of proof that had to be satisfied for entry of an amended claim into the patent. So in other words, the board has procedural limitations and requirements for entry of a motion to amend into the IPR. But the board has a separate decision to make of whether the claims are patentable or not. The Federal Circuit, in its en banc decision, did not challenge the board's practice of requiring each amendment to respond to an instituted ground of unpatentability. And there are some practical impacts as a result of this. First and foremost, we expect that new rules may be promulgated by the PTO in light of Aqua Products, but until then, motions to amend will require at least the same elements as prior to Aqua Products, except that the patent owner no longer has the burden of proof that the claims are valid. Instead, petitioners will have the burden of proof of invalidity. The practical impact of this is that claim amendments will be considered in a relatively short amount of time, and that instead of the burden being on the patent owner to show that the claims are patentable, the burden will now be on petitioner in order to demonstrate that the claims are unpatentable if the petitioner is to prevail. and this occurs in a relatively short time frame as shown in the red brackets on this timeline. So from the time that the patent owner response and motion to amend are filed to the time which the testimonial evidence and further briefing is provided is approximately 6 months. It's a relatively short time frame for petitioner to get its case in order. The various different due dates are set forth in this next slide. Due date 1 is when the motion to amend and patent owner response appear on the scene. Most likely, petitioner is going to want to cross-examine the patent owner expert because declaration evidence is likely to be attached to the motion to amend. Due date 2 is where the petitioner will have an opportunity to have filed a reply in opposition to the amendment and demonstrate its case for why the claims are unpatentable. It will too likely include some declaration evidence of unpatentability, which the patent owner may want to cross-examine in a deposition of the petitioner's expert. Due date number 3, the patent owner reply to petitioner's opposition to amendment is filed. This, of course, may also include declaration evidence of patentability, and of course, petitioner will likely want to cross-examine any patent owner witness for the reply. On due date 4, the petitioner will have the opportunity to file observations to the cross-examination of the reply witness. And on due date 5, the patent owner will get to respond to petitioner's observations. It remains to be seen if there are going to be additional requests for additional replies and briefing in light of the shifted burden from patent owner to petitioner after Aqua Products. It also remains to be seen if these one-year timers that the board has applied since the 1 year from the institution decision will be preserved in view of Aqua Products. Because if evidentiary considerations come to bear and require additional time, it may be necessary for the board to consider extending from the 1 year deadline that it has stuck to. And it can do so because it's been given an extra half a year in order to complete the IPRs per the statute. But the board has refrained from doing that in the past. In any event, the petitioner is going to have a heightened responsibility to demonstrate unpatentability of the substitute claims. Any resulting confirmation of patent claims will likely be interpreted as a failure on petitioner to show unpatentability. So now the petitioner has a little more on its plate than just to obtain institution of trial. The petitioner also has to show that any amended claims are unpatentable at the end of the IPR. And as I mentioned before, it remains to be seen if additional surreplies and other responsive papers are going to be requested from the parties. The Aqua Products decision does raise some interesting questions. One question is, will amendment practice increase post Aqua Products, or will amendments remain infrequent? In other words, will parties have confidence that amendments will get them something? There's always the concern of intervening rights and when making amendments too. So there's a natural inclination of patent owners to not want to amend unless absolutely necessary. But as we move on into more IPRs with patents that are younger in life than when we originally started the AIA, it will be interesting to see if amendment practice actually increases. It'll also be interesting to see if cost of IPRs is increased by virtue of the higher stakes for petitioners to show unpatentability towards the last 6 months before the oral argument. And again, it will be interesting to see if we see the board extend IPRs past the 1 year timer in order to accommodate some of the evidentiary taking at the end of the IPR proceeding. And at the very least, we'll be looking for new claim regulations and rules for claim amendments. With that, I'd like to thank you for tuning into this webinar. Please feel free to send me an email if you have any suggestions for future webinars or if you have any comments about this webinar. I look forward to hearing from you.